See, today we are going to discuss about the Citizen Charter Bill 2011. This bill is also called by other name called a right of citizens for time-bound delivery of goods and services and redressal of their grievances Bill 2011. So this is a topic where it comes exactly in the syllabus. You need to relate it to the syllabus. So in General Studies paper 2, that is polity paper, you have a chapter by name issues relating to governance, transparency and accountability. So this Citizen Charter Bill is directly linked to that particular chapter. It comes under that particular chapter dealing with issues of governance, transparency and accountability. So before we go into detail the provisions of the Citizen Charter Bill, let us give the relevance of the topic. For what reasons the Citizen Charter Bill is in the news. See, the Union government, it has introduced the Citizen Charter Bill in Lok Sabha in December 20, 2011. December 20, 2011. Subsequently, the Citizen Charter Bill, it was referred to a Parliamentary Standing Committee on Personal, Public Grievances, Law and Justice. So this Parliamentary Standing Committee gave a report on 30th August 2012. So the Parliamentary Standing Committee report is now available with Parliament. The bill is pending in the Parliament. It is yet to be passed by the Parliament. So this is the reason why this bill is in the news. And then let's consider the various provisions in the bill. What are the different provisions in the bill? What is the criticism of the provisions? And then what are the recommendations made by the Parliamentary Standing Committee to improve the provisions in the bill? So let's begin with public authority. So the bill says that after the Citizen Charter Bill becomes a legislation, once it comes into force within 6 months, every public authority has to come up with a citizen charter. In other words, the head of the public organization has to formulate citizen charters in partnership with stakeholders like citizens and non-governmental organizations. And apart from that, periodically the citizen charters have to be updated continuously. On a continuous basis, the citizen charters have to be updated, and this is the responsibility of the head of the public authority. Then, who is a public authority? What is the definition of the public authority in the Citizen Charter Bill 2011? So the bill says that a constitutional authority like the Finance Commission, the Election Commission, Comptroller and Auditor General, Union Public Service Commission, all these authorities which were mentioned in the Indian Constitution, that is the constitutional authorities, they are defined as one category of public authority. Then statutory authority, that is an authority which is set up by an act of parliament, by an act of legislature, by an act of parliament or by an act of legislature. To give an example, if you take the Right to Information Act 2005, based on the Right to Information Act 2005, Central Information Commission, State Information Commission, they were set up. Similarly, at the national level, there is this body by name National Commission for Protection of Child Rights. This is set up through that legislation, NCPCR legislation. Similarly, National Commission for Minorities, National Commission for Backward Classes, National Commission for Women. All these authorities, they were set up by an act of parliament. So they are called statutory authority. So along with constitutional authority, statutory authority is also defined as public authority. Then government company, government corporation like the National Thermal Power Corporation, Andhra Pradesh State Road Transport Corporation, all these which were set up by an act of parliament, they are also defined as public authority. Apart from that, the authorities which were set up as part of public-private partnership projects. Government of India is implementing several public-private partnership projects. For example, if you take the Shamshabad International Airport, that is a public-private partnership infrastructure project. Similarly, Rajiv Arogyashri, it is a public-private partnership scheme. Similarly, the Hyderabad Metro, it is a public-private partnership project. So the authorities which were set up as part of the public-private partnership project, they are also defined as the public authority. Apart from the constitutional authority, statutory authority, corporation, and this, what is this recent one, public-private partnership project. Even non-governmental organizations which are substantially funded by Government of India or the state government or the local government, they are also defined as public authority. Then every public authority has to constitute information facilitation center within that public organization. If the citizens come there, if they don't get the service within the stipulated time, if they want to make any complaint, so they need some support. So to give support to the citizens, information facilitation centers, they are called by several names. For example, customer call centers, citizen support centers, something like that. So every public authority has to set up information facilitation center in each public organization. And then, so what is the remedy for the citizen? For example, I will apply for a ration card, I will apply for a caste certificate, for an income certificate. If I don't get the service in the stipulated time, if the public authority says that we will provide you the so and so service in so and so time. For example, for ration card, if they say that we will provide you the ration card within 10 days, if they don't provide me the ration card within 10 days, then what is the way forward? What the citizen can do? Here the citizen can make a complaint to the grievance redressal officer who was appointed within that public organization. Got the point? Now I am discussing about the grievance redressal mechanism. If any citizen, if he doesn't get the public good or service within the stipulated time period, he can make a complaint to the grievance redressal officer who belongs to the same public organization, appointed by the head of the organization. And the bill says that the grievance redressal officer should redress the grievance of the citizen within 30 working days. Within 30 working days. If the citizen is not satisfied with the grievance redressal officer, then what he can do? Above the grievance redressal officer, there will be a designated authority. But this designated authority will be outside the public organization. Grievance redressal officer will be part of that public organization. He is an officer of that public organization. But the designated authority who is above the grievance redressal officer, he is outside the public authority. So if the citizen is not satisfied with the grievance redressal officer, the citizen can make a complaint to the designated authority who is above in rank compared to the grievance redressal officer. And the designated authority has to redress the grievance of the citizen within 30 working days. If the order passed by the designated authority is not satisfactory to the citizen, or if the designated authority fails to redress the grievance of the citizen, then what is the remedy for the citizen? He can make a complaint about designated authority. There will be organizations like State Public Grievance Redressal Commission, if it is a state government service, the service which the citizen has demanded, if it is a service to be provided by the state government above the designated authority, there will be State Public Grievance Redressal Commission. And if it is a service to be delivered by the central government above the designated authority, there will be Central Public Grievance Redressal Commission. So the citizen, if he is not satisfied with the designated authority, he can make a complaint to the State Public Grievance Redressal Commission or the Central Public Grievance Redressal Commission, as the case may be. And if it is a case which involves corruption, if the complaint made by the citizen involves corruption, because if I apply for a Pattadar passbook, the VRO, he may fail to deliver the service within the stipulated period. That is a general grievance for which I have the redressal mechanism. And if he demands some bribe from me, say 2000 rupees to get my passbook in time, so here the official is taking the money and it is an act of corruption. So if a complaint relates to corruption, the final appeal will be the Lokayukta or the Lokpal. First grievance redressal officer, above that designated authority, above that state public grievance redressal commission, above that Lokayukta, if it is a service to be provided by the state government. Similarly, if there is any complaint of corruption with respect to service to be provided by the central government, the appeal will be like this. First appeal to the grievance redressal officer, the next level designated authority, the next level central public grievance redressal commission, and the final appeal is to the Lokpal. This is the mechanism available. So a complaint which was taken to the state public grievance redressal commission or the central public grievance redressal commission, it has to be redressed within 60 working days. For the grievance redressal officer and for the designated authority, what is the time stipulated? 30 working days. But for the state public grievance redressal commission and for the central public grievance redressal commission, the time period within which they have to redress the grievance of the citizen is within 60 working days. So this is the grievance redressal mechanism. And then what is this state public grievance redressal commission and what is this central public grievance redressal commission? What is the composition? What are the qualifications? How they are appointed? How they are removed? So let's look into this issue. State public grievance redressal commission. See, every state public grievance redressal commission will be consisting of one chief commissioner and not more than 10 commissioners. In total 11 will be there. One chief commissioner and 10, not more than 10 commissioners. Out of these 11 people, there should be representation to SC, ST and women. Then who are eligible to be appointed as the chief commissioner or the commissioners? The following people are eligible. Principal secretary to that particular state government, either serving or retired, he is eligible. And then judge of high court, serving or retired, he is eligible. A district judge who has put in service for 10 years, he is also eligible to be appointed as the chief commissioner or other commissioners. Here also serving or retired. Then an eminent citizen who has experience in the social work for 15 years, and along with that if he had a post-graduation degree, even this person is eligible. These are the categories of the people who are eligible to be appointed as the chief commissioner and other commissioners. Who will appoint these people? The governor will appoint. Who will recommend the names? There will be a selection committee. And this selection committee will consist of 3 people. Chief Minister, Leader of Opposition in the Legislative Assembly, and a Judge of High Court nominated by the Chief Justice of the High Court. These 3 people will make the selection. Selection committee will identify the people to be appointed as the Chief Commissioner and other commissioners. Finally, the governor will appoint. To assist the selection committee, there will be a search committee. To assist the selection committee, there will be a search committee. The qualifications of the search committee, they were not defined in the bill. And then, what about the salary and other allowances for these people? The Chief Commissioner of the State Public Grievance Redressal Commission, the Chief Commissioner's salary and other allowances will be equivalent to Central Election Commissioner. The other commissioners, their salary and other allowances, they are equivalent to the Chief Secretary of that concerned state. Fine. Then the governor may remove the Chief Commissioner and other commissioners on the following grounds. Insolvency. One ground is insolvency. The second one is infirmity of mind and body, if he is not mentally fit and physically fit. The third one is he is not expected to engage in paid employment outside the office. If he engages in any paid employment outside the office, then he can be removed. And apart from that, if he is convicted for any offence relating to morality, then he can be removed. These are the 4 grounds. One is insolvency, infirmity of mind and body, then engaging in paid employment outside the office, and convicted in an offence involving morality, that is, his guilt is proved. These are the grounds on which the governor can remove chief commissioner and other commissioners. For other reasons, that is for misbehavior or the corrupt behavior, the chief commissioner and other commissioners will be removed through a procedure which will be defined in the rules and regulations. The details were not there in the original bill. This is about State Public Grievance Redressal Commission. And then let's move to Central Public Grievance Redressal Commission. This is almost similar to the State Public Grievance Redressal Commission. So even the Central Public Grievance Redressal Commission, it will consist of one chief commissioner and not more than 10 commissioners. And out of these 11 people, 1 plus 10, 11 people, there shall be representation to an SC, ST and women who are eligible to be appointed as the chief commissioner or other commissioners. Secretary to Government of India, an officer of the rank of Secretary to Government of India, is senior most IAS officer, serving or retired. Then Judge of Supreme Court or Chief Justice of High Court, serving or retired. Here be careful, a Judge of High Court is not eligible. A Chief Justice of High Court or Judge of Supreme Court, serving or retired. Then an eminent citizen who is engaged in social work for 20 years along with a post-graduation degree. All these three categories of the people, they are eligible to be appointed as the chief commissioner or other commissioners. So who will appoint these people? The president will appoint based on the recommendations of a selection committee consisting of Prime Minister, Leader of Opposition in Lok Sabha and a Judge of Supreme Court nominated by the Chief Justice of India. And the selection committee will be assisted by a search committee. And what about the salary and other allowances? The salary of the Chief Commissioner of the Central Public Grievance Redressal Commission is equivalent to Chief Election Commissioner, not Central Election Commissioner. Chief Election Commissioner is above the rank of Central Election Commissioner. Keep this in mind. At the union level, we have Election Commission, which consists of Chief Election Commissioner and 2 other election commissioners. So, the Chief Commissioner of the Central Public Grievance Redressal Commission, he will get the salary what the Chief Election Commissioner will get. The other commissioners of the Central Public Grievance Redressal Commission, they will get the salary what the Election Commissioner gets. Fine? So, the President can remove the Chief Commissioner and other commissioners for the same reasons. Insolvency, if he engages in paid employment outside the office, if he is convicted for any offence involving morality and infirmity of mind or body. And apart from that, for proven misbehavior or for proven corrupt behavior, also the members will be, that is the Chief Commissioner and other commissioners, they will be removed. But the procedure is not defined in the bill. It will be subsequently taken up in the rules and regulations which will be formulated in course of time once this legislation is enacted in the Parliament. Then, what is the penalty? Here, the maximum penalty on a public servant who fails to deliver the service in time is 50,000 rupees. Who is eligible to levy that penalty? The designated authority, Central Public Grievance Redressal Commission or the State Public Grievance Redressal Commission. These 2 bodies, they are eligible to levy the penalty. Grievance Redressal Officer can only recommend the designated authority to levy penalty. Grievance Redressal Officer can recommend the designated authority to levy penalty. He can make only recommendation, but the actual levy of penalty can be done by the designated authority or the Central Public Grievance Redressal Commission or the State Public Grievance Redressal Commission. Here, another important feature of the bill is, if the citizens are not getting the services and goods in time, it is always not necessary that the citizen should make a complaint. Even sumoto, that is voluntarily on their own, the State Public Grievance Redressal Commission or the Central Public Grievance Redressal Commission can take up the matter. It will refer to the concerned head of the public authority to look into the issue, why you are not able to deliver the good and service within the stipulated time. And it can also order an inquiry on its own, even without a complaint of citizen, for the non-delivery of goods and services. This is one important provision. And then